Hello there, viewers, and welcome to Vienna Arbitration Talks. Vienna Arbitration Talks is a series of videos that we here at Konrad Partners do and invite prominent arbitration practitioners to Vienna to discuss topics in international arbitration. Today I'm very happy to host Jeremy Sharpe, who is currently in Vienna as a member of the United States delegation to Working Group 3 of UNCITRAL. As you may be aware, Working Group 3 is dealing at the moment with the reform of investor-state dispute settlement, and Jeremy has been so kind to come here to our offices. Welcome to Vienna, Jeremy, and great to have you here.
Thank you so much, Peter, for the invitation. It's wonderful to be in Vienna and to be here in your exquisite offices. I would just note that it's true I'm here on behalf of the US delegation, but I'm appearing today in my personal capacity.
Of course. Thanks, Jeremy. Let me introduce Jeremy shortly. Jeremy is a partner at the International Arbitration and Public International Law Practices of Shearman Sterling. He's based in Paris now, but he was based in London before. Jeremy specializes in international investment arbitration, which is what we will talk to him about today. And Jeremy previously served as Chief of Investment Arbitration in the Office of the Legal Advisor of the US State Department, where he represented the US in investor-state and state-to-state disputes under bilateral investment treaties and investment chapters of free trade agreements. Since Jeremy has joined Shearman Sterling, he has represented a number of other states also, but of course also investors in investor-state arbitration. So Jeremy's vast experience in representing sovereign states, of course, makes him a very good guest, a very good candidate for today's topic, which is the ability of states to engage effectively in international investment arbitration. Or in other words, what can a state do to be more efficient and more effective in investment arbitration as a respondent? To do that, I would suggest that we first look at the specific issues that the state needs to think about when it's a respondent in investment arbitration, issues that a private party maybe would not have to face in commercial arbitration. So, Jeremy, in your experience, how is representing a state different from representing a private party?
Thank you, Peter. It is challenging for counsel for states to represent them effectively in arbitration. Partly it's a consequence of the nature of the cases themselves. They tend to involve important public policies like the environment or public health. The scrutiny can be higher because these are public cases and you receive greater scrutiny by lawmakers, members of the government, by the press, civil society, and partly it's a consequence of the huge financial stakes that some of these cases raise. It's very challenging for states to defend themselves when the amounts claimed can be, for instance, greater than the foreign currency reserves of that state. A second reason is perhaps the nature of the state itself. A private party has different interests when it's prosecuting a claim under a treaty. It doesn't have the same concerns. If you're retained by a claimant in an investment dispute, it is to make the arguments that you need to make, consistent with your ethical obligations, to win. And your concern is not the long-term integrity of the treaty or any concern about being a future respondent in a case. Claimants might have an incentive to pitch their claims at the highest level because they're not worried that their words are going to be used against them in future cases. But a state is different. It is a repeat player under the treaty. The words used by a state in a proceeding can be used against the state in future proceedings or against investors in future proceedings. So the state has to be very mindful, and counsel for the state have to be mindful about the arguments advanced. States can't make any available argument just to win a case. And if you think about how a counsel might look at the nature of a state in a case, of course the state is a sovereign entity and you have to be concerned about the interests of the state, the well-being of the people and so forth. But a state, even as a respondent in an investment case, could be not only acting from the perspective of a capital importer and therefore making arguments that reveal to the world how a state treats an aggrieved foreign investor, but also potentially as a capital exporter and the arguments that could impact investors, its own investors, precisely. And even beyond that, you have the state as a whole that comprises all the different ministries of the state or even subnational entities. So your client might be a particular line ministry whose actions gave rise to the dispute. But the ultimate interest is the interest of the state as a whole, and you have to have a broader perspective. And then the arguments of the state themselves could be evidence of state practice or opinio juris. The state plays a role as a lawmaker and not just as a defendant or a potential lawmaker in a case. Add to that the fact that the state's actions in the arbitration can implicate the state's interest vis-a-vis the home state or third states. You realize it's an incredibly complex situation for states and for counsel for states to try to understand and protect all of these interests at the same time, which is very different, of course, from when you're acting for a private claimant.
No, I read your article on basically your book chapter on representing states, and there you mentioned also maybe there's more organizational issues, especially in, for example, finding documents, finding witnesses. We all know that maybe the public employees may have a bigger turnover than in the private sector. So I would imagine maybe the institutional memory, as you say, is shorter also, right?
Exactly. It's a major problem. If you think about when you're representing a private claimant, you generally have the advantage of time to put your case together, obtain the relevant documents, and the claimant tends to have the documents within the company itself that you can draw upon. And when you're representing a state, you're exactly right. You might be dealing with multiple ministries. There's been enormous turnover in personnel. You can't get witnesses to testify about the events that occurred in the arbitration. And so you realize that on one hand, the state is a powerful actor and has all the powers of the state that could exercise against the claimant. But on the other hand, the state could be a very encumbered actor and may not be able to mount an effective defense precisely for the weaknesses that you identified, obtaining the relevant documents, finding witnesses who can testify, and then marshaling all this effectively to present an effective defense for the state is challenging.
I would imagine even in document production exercises, it's probably challenging for states to find these documents. For some states, because maybe they don't have, as you said, it can't really find documents to prepare its own defense, but even maybe when it's requested to produce some documents, it may be a similar story, right?
Absolutely. There are stories of states that haven't even been able to identify the investment treaty upon which the claim has been brought and had to ask the home state to provide a copy of the treaty. States maintaining and retrieving the documents can be enormously challenging for states.
So Jeremy, we can probably solve a couple of these things, especially those related to the organizational matters. And you used to be the chief of investment arbitration. In other words, the main representative of the US in investment arbitrations. And as we know, the US always relies solely on in-house counsel. How come the US has never lost a case so far? And what lessons could the other states learn from the US?
Thanks, Peter. I think the answer partly lies in perhaps the nature of the claims that have been brought against the United States, perhaps the nature of US treaties, which tend to be drafted a bit differently, and perhaps the fact that the United States is a very litigious society and the agencies are always operating under the specter of potential lawsuits domestically. But part of it is institutional, and the United States has a great advantage in many respects. We have had an Office of the Legal Advisor for many decades, and in the early 80s had to establish an office to defend the United States at the Iran-US Claims Tribunal, where some 3,000 claims were brought. And so the institutional arrangements that were established to deal with the Iran-US Claims Tribunal cases were then usefully transformed to assist with investment arbitration. And I think there are probably 5 pillars of a state's organizational capacity for responding to investment claims. The first is simply standard operating procedures for responding to notices so that when a claimant sends in a notice of intent to bring a claim, it doesn't languish in some ministry with the relevant person not knowing what to do with this. It goes to the office in the United States immediately that's responsible for defending the claim. And that's a huge advantage right there. You don't waste months or even a year simply because you don't know about the existence of a dispute. The second is authorities. The United States has a lead state agency, the State Department, which is responsible for the defense of the United States in these claims. So additionally, no time is lost trying to sort out which ministry is responsible and trying to organize the ministry to respond to a claim. The third is coordination. The United States has an interagency process established to coordinate internally so that documents can be obtained and relevant witnesses can be found and so forth. And also guidance can be obtained from the whole of the government on proceeding with the defense of the United States. External coordination is equally important, having processes in place to reach out to treaty parties, for example, on interpretation of the treaty and so forth. The fourth is counsel. As you mentioned, the United States represents itself, and so many states have struggled to find quality counsel quickly, and to be able to have counsel in-house that can immediately turn their minds to the case and begin to organize the defense for the case is enormously valuable.
I was thinking that these, you've mentioned it can take a long time to get these counsels. Even when the state knows exactly what it's doing, it has to maybe do some public procurement procedures that may take a while for to be able to instruct the council, right?
That's absolutely right. I think some states have recognized this as a problem and have sought exemptions from the normal procurement practices so they can obtain counsel very quickly, or have vetted counsel in advance. So they have a pre-approved list of counsel that they can go to on short notice. But you're absolutely right. States can waste enormous amounts of time going through the ordinary public procurement process for counsel when that time is desperately needed to prepare for the defense of the case.
Do you know, do they usually ask for extensions of deadlines for the answer to the request, all these kind of things, I would imagine?
I think a lot of states that don't have the practices in place are suffering from some of the other problems as well. So in the worst case scenario, the notice of intent stays with the line ministry, or sometimes multiple ministries are copied and no one takes responsibility, or the notice is sent to the Prime Minister's office as well as various ministries, and many times the other ministries will think, well, if it's with the Prime Minister's office, we don't need to respond. They don't take action. They don't know who the lead state agency is, so no one's seeking to obtain counsel. And then the case proceeds. There is finally a letter perhaps from the appointing authority saying you failed to make an appointment and we're making a default appointment. You failed to attend the first session. A first procedural order has been established. The claimant has submitted a memorial. Your counter memorial is due or past due. And by the time respondent's counsel is brought on, months or even more than a year has been wasted. So for some states that have difficulty with public procurement, they're also suffering from some of these other institutional defects in investment arbitration practices.
And this can basically, the United States does not have to deal with any of this, right?
Exactly. Or we still face problems in each of these. Even in a case you might find that you don't have the relevant authorities to get documents from a particular ministry, simply because Congress never anticipated that the State Department would need to obtain documents from that ministry. So some special arrangements might need to be made. The United States generally has these 5 pillars sorted out, but of course you can always run into difficulties because you can't foresee every eventuality. I'll just mention the 5th pillar, which is money. These cases tend to be very expensive, and in the context of setting up the defense of the United States for the Iran-US Claims Tribunal, a litigation fund was established, which the United States could then use for the International Court of Justice and then later for investment arbitration. And again, that's enormously important to have the funds available to begin the defense of the case, to hire necessary experts and so forth. And so the result of this is you put the state in a much better position to defend itself effectively, so that if you do lose a case, it's not because of some institutional defect, it's not because you haven't mounted the best defense possible for the state. And unfortunately, I think states have lost cases or have paid more than they might have otherwise paid on awards simply because of defects in the institutional arrangements for mounting an effective defense.
When we're talking about the institutional arrangements, you have recommended that the state appoints an agent also when they are represented by external counsel, that a state agent is appointed. Why do you think this is so important?
I began thinking about this at the State Department when I still worked there. It's a curious thing. In almost all international litigations, the state will appoint an agent to be the formal diplomatic representative of the state before the tribunal. The agent also helps coordinate and manage the case, dealing with some of these institutional issues we discussed. But also, the agent can help formulate the state's litigation positions. And this is something that's lost entirely, or can be lost, if the state immediately hires outside counsel and doesn't take ownership of the defense of the state, the legal arguments being advanced on behalf of the state. And it's a problem because there are tools that are available to states in the investment arbitration system to help control the development of the law. Primarily, of course, as a respondent state through the state's pleadings, provided that the state has provided input on what those pleadings are, provided that the state shows that those pleadings, in fact, are meant to reflect and do reflect state practice and opinio juris. But also, there are avenues for states to participate as non-disputing parties, whether through non-disputing party submissions, through joint interpretations, through set-aside proceedings in courts, or even through unilateral statements. But all of these things are theoretical tools if the state doesn't have the institutional arrangements to be monitoring these cases and to be exercising these tools. If the state simply turns its case over to outside counsel, it is potentially forfeiting the state's ability to try to control the development of international law through these cases. I think the appointment of an agent is the simplest, easiest, most cost-effective way for a state to centralize this authority and to ensure that at least there's one person who's responsible for oversight over the cases, for ensuring that the institutional arrangements are in place for the effective defense of the case, and for ensuring that the legal arguments advanced by the state properly reflect the long-term legal and policy interests of that state and can monitor disputes involving the other treaty parties and intervene as necessary.
I would imagine you have quite some experience with working with agents. Then when you're instructed as external counsel, would you then recommend the state to appoint an agent?
I haven't had the opportunity to recommend the state. I just published this article recently, but I'm hopeful that states will recognize that outside counsel will be open to this. I think it should be a relationship of partnership and in no way a competition between the state and its outside counsel, but that states will themselves recognize the benefit of having a person who is responsible for the case and is willing to put his or her name in the signature block of each pleading to appear before the arbitral tribunal and to announce his presence as the agent for the state. And then it will be clear to all concerned, including the arbitrators, that these pleadings are the representation of the state itself, not a simple ministry, and certainly not the personal opinions of outside counsel, but fully reflect the considered views of the state itself.
So helps with the credibility of the submissions, right?
Exactly. I think it will make the state a more credible litigant, it will make it a more reliable litigant, and I think it will improve the legitimacy of the process as well, because there'll be no question about the motives of the state making any particular arguments or any of the actions that the state might take in the arbitration.
Thank you so much, Jeremy, for your time. This has been wonderful. We hope to be able to host you here again very soon. You'll be in Vienna in a couple of months, as I understand. But in the meantime, thank you for watching, and we're looking forward to our next episode of Vienna Arbitration Talks. Thank you and goodbye.